will be engaged in. This requires to put in supplementary affidavits to the affidavits from our clients' criminal justice system, which is completely as a separate proceedings, which are so unique in nature that we take to the stand, cross-examine those individuals we need to cross-examine within the limits of individuals for cross-examination. One of the individuals that I'm inviting is may be relevant in assisting the court to go to the depth of this matter. Number two, Your Lordship, is Mr. Government.
My Lord, sorry, I know the court gave directions, but please guide us. On the side of the rest investigators, who was brought by Mr. Nyamoti in the court, who will tell us the least amount of time, because beyond leads which the police may want to follow, those leads cannot be followed in one day. So we pray that on the part of the audience, release, which the petitioners have chosen to call production. Lord, I will not say so much, but I want to share with you a decision of the Supreme Court of this country. The state of Mwangi Stephen Muriji and the Abu and Mohammed AC serving as the executrix of the estate of Honorable Daniel Koitich Arap Moi, and was never fashioned to grant leave beyond release of a person from unlawful custody. The grant or denial of the writ does not deprive an. The matter ends to that extent. To the question of the seventh petitioner, I urge you to agree with me and thank you.
I hold somebody for 2 years, a year. That's the reason as to why 2010, the Constitution of Kenya made it very clear that if anybody's held means of a charge sheet or a miscellaneous application for custodial case, yes, if it extends to look for violations of my good brother, which has put it very clearly, moves to investigations. My Lord, number two, look at the constellation of the officers before you, starting from the Inspector General of Police. Deals with intelligence becomes a subject matter on abductions. My Lord, I urge you to look at the scope, show that the DCI has the person who has not, that it is not released from police custody. None or anybody has produced evidence that they were released from a police station. They are here. In this, we are in the dark, my Lord. We urge that be a concern for every Kenyan. Only the police. Is that somebody missing, already dead? Is that somebody missing in the hands of government agencies? That will take time. And that's why I agree with my brother, Mr. Nyamoti, that 14 days will be sufficient to bring to you a status report that the court can make a decision on.
Yes, my Lord. Your Lordship, perhaps I have listened and Lord, everybody seated at this bar, undermining the authority of this court and the order that you issue. We ask for this compliance with order number 3, and that is the appearance of the inspector, bearing in mind that, my lords, there are ex parte orders that have been issued by this honorable court. And for example, a petition of order number 3, that if the court maintains that it is Mr. Nyamoti is asking for, we hear the notice of motion application. So that, and my lord, bearing in mind that the enforcement of rights is under Article 25 of the 7th respondent, and we have filed a reply to that application, my lord. If you allow and ask that application, so that we are going to renew a ruling, because this is a court of record, so that within the number of days we give based on the aspects that will be responded. Therefore, to me, to my mind, I believe, without to underscore the importance of the matter before you, we still have the other miscellaneous application number 216.
Yes.
Where if, for example, orders of at least the respondent to look at the material that have been placed before and make an informed decision as either to the continuous appearance of. And I say that, my Lord, with tremendous respect, because under Article 245 of the Constitution, by the first interested party, the second interested party, in terms of enforced disappearance, Inspector General of Police by the affidavit that have been filed, that they are. What I foresee, my Lord, is that given especially if at all what is alleged that the state actors are holding this person, the first respondent under Section 6 of, and that dispute ultimately will come to the judiciary for determination. My plea, my Lord, that we hear their notice of motion application quickly.
Yes, my Lord.
Yes, my Lord.
Yes.
Before I answer the question of time, it's people, their rights, freedoms, property, and national interests. So, my Lord, I would request that when you talk about the application for the release of this raid, that article to the end, and also look at Article 2. There. So the application by the is calling upon the duty bearers to perform their functions. And so the internal threat, police who are listed as the security organs, the NIS, and even the military, ends the way I've not had a law for me is Article 23, where applications for enforcement of rights, what the court hasn't given the power to, the power the court has been given. Another thing, the power the court is. First of all, it will be a bit difficult to say that. It's another problem. That these people don't deserve any time. Acceptable that the number 7 should know where he is, and people are asking for time to investigate when because after leaving my office, I want to make a report about Quebec. Petitioner is not here, and the Inspector General of Police comes in person. To tell us why he cannot deal with that internal threat, that he answers salary.